We are here for final argument of today's State of Ohio versus James, also known as Jamie Collins. Each party will have 15 minutes to present its arguments. The appellant may reserve up to 5 minutes for rebuttal. If you wish to reserve rebuttal time when you take the podium, just let me know and I'll do my best to track that for you. Arguments are being visually and audibly recorded and be posted online, so please keep your voices up, remain behind the podium. Do not use the name of any children here. And we have read your briefs and we're ready to proceed when you are.
Yeah, this podium, the small one?
Front one.
The front.
Yeah, front one. Thanks. Do you want to reserve rebuttal time?
Yes, I'm going to ask to reserve 3 minutes, please. Good morning, Your Honors. Attorney Catherine Meehan, I'm here representing the appellant James Collins in this case. Today we're essentially here to challenge the validity of the plea that was entered in this case, as well as some of the additional things that happened after the plea, including sentencing, and whether or not the appropriate factors were considered in determining the sentence in this case. I do want to start by addressing our first assignment of error and the validity of the plea. In order for the plea to be valid, it has to be knowing, intelligent, and voluntarily entered. And one of the ways that we ensure that is Criminal Rule 11, as the court is well aware. We're dealing with, specifically in this case, a non-constitutional right, and that is the right of the defendant or the appellant in this case to understand the effect of the guilty plea entered. I think that there are some issues here in terms of the colloquy that happened with the trial court, specifically in explaining to the appellant the effect of entering a guilty plea in this case to the indictment. Some of the language used by the trial court is a little bit relaxed in terms of informing the appellant what it actually means to enter a guilty plea, and I think that's significant because it kind of downplays the importance of and what is actually expected of an appellant or the defendant in this case when she entered the plea. Looking at the language from the transcripts, one of the things that strikes me as a bit unusual is how relaxed it was. The court notes, when you're entering, when discussing the plea, you're saying, you know, Judge, I'm taking responsibility for violating the law and I'm willing to give up my right to a trial and all other things. I just want to get the case over with, put it behind me, and try to move on with my life. That language, I just want to get the case over with, put it behind me, and try to move on with my life, I think fails to substantially comply with actually letting the appellant know in this case that she's taking full responsibility and admitting to her guilt to the indictment in this case. One of the things that I think is actually significant, and I think one of the reasons why Criminal Rule 11 was created, was because there's no doubt in my mind that we have people that end up in situations and actually plead guilty to things that they didn't do. And I think when we're looking at an indictment, when you have a case that has multiple counts, so this case had 15 counts in the indictment, when we're looking at that, it's not as if the appellant has the opportunity to say, yes, I'm guilty of these 5 things, but not the other 10. I want to plead on these 5 things and go to trial on the others. That's not how it works. So I think it's important when you're actually entering a plea, especially to a case that has multiple counts, for the court to inform the defendant or the appellant that you are admitting to full guilt to each and every one of these counts in this indictment. And I think that's a little bit lacking here. Even looking at the state's argument about ambiguity within the plea colloquy and whether or not there is a written agreement that you could look to other things in the record to see if there was substantial compliance. One of the things that the state notes is out of the Beach case where the ambiguity in the colloquy allowed the court to look at other things, including the written plea, and in that case, the court had indicated that the appellant actually had the opportunity to be informed by both the attorney and the judge in that case. And I think that's where there's a little bit of a distinguishing factor with our case, because when we turn to the actual written plea agreement here, I believe it's paragraph 5, and that, again, the state notes to paragraph 5, that option actually says, did your lawyer explain this to you? And Criminal Rule 11 doesn't require the attorney to do it. This is talking about the trial court. It's the trial court's obligation to substantially comply with Criminal Rule 11. And I don't think that that actually demonstrates, this written plea agreement, I don't think even helps the argument that there is substantial compliance. And so when we're looking at the validity of a plea where somebody is not actually informed of the effect of a guilty plea and what that actually means, the issue that I have is that if that's okay, if the court doesn't do this, then we're essentially validating something that someone didn't understand. And that's why we would ask the court to essentially take this case back to the trial court and vacate the plea and allow this case to reset. I do want to turn my attention to our third assignment of error, and that is in regard to the sentence in this case, specifically whether or not the appropriate factors were taken into consideration by the trial court. And one of the things that I think is significant is that we are looking at a case where the appellant received a 26-year sentence based on the plea here. Specifically, we were looking at the seriousness and recidivism factors, which the trial court is to consider before fashioning a sentence, and that's because this was a case dealing with higher level felonies, and those higher level felonies do carry the presumption of prison. I do recognize that there are some serious factors that did apply. I know that the court wasn't specific within the transcripts and within the sentencing entry what the findings actually were, aside from the factors that make this more serious outweigh those that make it less serious. And the same thing with the recidivism. I believe the entry indicated that factors that indicate more likely to commit crimes in the future outweigh those that are less likely. And reviewing everything, I just don't think that's the case, and that's a lot of what we pointed to in the brief deals with the recidivism factors and what the court actually considered. There was a point during the transcripts where the judge actually said at the sentencing hearing that recidivism was more likely due to the length of time of the incidents in this case. I mean, there was a complete failure to acknowledge the fact that Ms. Collins has no prior criminal history, had no adjudications as a juvenile, had lived a law-abiding life for her entire life, and showed remorse at the time of sentencing. And I think without weighing those factors, I don't know how the court can actually say that recidivism is more likely when she has all of these factors that actually demonstrate the opposite. So one of the things, and this kind of reminds me of a case that actually happened after the briefs were due in this case. It was a case out of the 11th District. It's State of Ohio versus Polizzi, 2019, Ohio 2505. That case was from, I believe it was the end of June. This reminds me of that case because that was a case where there was, the appellant in that case was charged with over 80 counts of sexual battery and gross sexual imposition for relationships that he had with several of his students while he was a teacher. And the judge in that case gave him a 33-year sentence. And some of the things that are similar from that case are actually similar to this case, where we had obviously harm to the victim was exacerbated due to the age of the victims in that case. The relationships facilitated the offense. There was serious physical harm there and psychological harm. But then same kind of thing, no recidivism factors, no criminal record, no juvenile adjudications, remorse, and the 11th District overturned that sentence, vacated it, and remanded it to the trial court. That's something that just rings true to what happened in this case. It just has a lot of familiarity to me when I'm looking at that decision and the facts and what happened in this case. So overall, I do think that the court should invalidate the plea at this time because Ms. Collins was not properly advised on the effect of her plea. In the event the court disagrees with that, I would ask the court to consider remanding and vacating the sentence and having it set back for resentencing.
Counsel, I guess, given that this was, I'm going to use your word and say lax language, what would there have been that your client didn't understand about her plea?
Well, and I think that's one of the things that I spoke to earlier in the argument is that it's kind of a dangerous line because we do have people that are kind of put in situations where sometimes they have no other choice but to enter a plea. And so I think...
Well, hang on for a second. I don't remember, 15 count indictment, something like that?
That's
here?
correct.
You can plead to some and not the others, or if the court won't do that, you could go to trial and concede to some and not the others. That's done. You know, ladies and gentlemen of the jury or court, we're not gonna take up your time on these, but, so I guess that's where I'm struggling, because I don't, it's an all or nothing in the sense that the state's not willing to dismiss some, but if you truly want to challenge some, what was there about the judge's language that would lead her to believe this wasn't finished?
I think, like I said, I think it is, it's just, the rule, the language in criminal rule 11 for the actual effect of your plea is this is a complete admission. And I do recognize that you don't have to actually state the word for word language, but it has to be clear during that colloquy that that's what's happening. And I don't think when we're reading this language here that that actually happened. And I think it's important, and that's why I noted that I think it is a bit relaxed, because the judge does say, I just want to get this case over with, put it behind me, and try to move on with my life. To me, that doesn't, it's kind of putting a different meaning behind what's actually happening.
It's almost like an Alfred kind of thing.
Perhaps it's, like I said, it's kind of, it's relaxed in the sense that I don't think it adequately or substantially complies with what's required by criminal rule 11. Is there no other questions?
Reserve the remainder of your time for rebuttal.
Thank you.
One final time, Brian Murphy, Assistant Prosecuting Attorney, Lorain County Prosecutor's Office. Judges, with regard to the first assignment of error, what this really comes down to is the judge saying admission, you are admitting to violating the law, versus that the effect of your plea is you're admitting to violating the law, versus the effect of your plea is a complete admission of guilt.
So you're agreeing, I haven't read the actual transcript yet, obviously we all will, but so you agree that the trial judge told the defendant that she was entitled to trial by jury, and that if pleading guilty she would waive that right?
Yes.
And said it orally in open court?
Yes.
Okay.
Yes.
And all the other things that are under Rule 11, and the only thing is just in regard to the, what you're pleading to.
Rule 11B, the effect of the guilty plea. The effect of your guilty plea is a complete admission of your guilt, is what the rule says,
So
essentially.
there's no other denial?
No, and I don't believe that Ms. Collins argues that there was a denial of any constitutional advisements. So what we are here to determine is whether the judge substantially complied with ultimately 11, Criminal Rule 11B, this non-constitutional right. What he said was, you are admitting to violating the law. So he leaves out completely admitting. For all practical purposes, I don't know what completely admitting versus partly admitting to violating the law has any practical effects for a defendant. So completely admitting to violating the law, violating the law is being guilty.
So you're equating it the same as saying you admit that you're admitting guilty to all the charges in the indictment.
Correct.
So violating the law equates all the charges in the indictment.
Correct. That's what Ms. Collins was facing, the charges in the indictment. Violations of the law were those alleged in the indictment. And as courts have pointed out, slightly deviating from that language is okay, as long as the totality of the circumstances shows that the defendant subjectively, not objectively, but subjectively understands the implications of the plea and the rights waived. This court, you could look to the Stoddard case cited in the state's brief, in which the trial court said there would be no further proceedings Here, the court maybe set it a little more as Ms. Collins has asserted, you've described. Here, you're going to get the case over with, but there will be no more proceedings over guilt. You're giving up your appeals rights. The in Stoddard, the court cited here, the same occurred. And also that the state wouldn't need to prove that Stoddard was guilty beyond a reasonable doubt. Here, the same, and that there would be no further proceedings, and the other rights the trial court reference were waived. The 8th District and Moore found the language that the court used, specifically the defendant was admitting the truth of the charge to which you're pleading, substantially complied with 11B. The speech is relied upon by Ms. Collins and ultimately probably wrongly, because what the Beach Court concluded here in the 9th District was that the appellant failed to show any prejudice. And well, frankly, Ms. Collins' brief failed to argue and demonstrate any prejudice. Didn't even argue the prejudicial prong. The sentencing hearing, with regard to, and I'll go to the third assignment of error also regarding the sentencing hearing and the 29-29-11 principles, the 29-29-12 seriousness and recidivism factors, and look at the assignment of error and what was asserted to you here at argument today, and were those factors taken into consideration. That's the way that this argument's framed. That's the way this error is framed. Were they taken into consideration? And the fact of the matter is they absolutely were. They clearly were. The trial court says on the record and in journal entries that it considered the purposes and principles of sentencing under revised code section 29-29-11 and also the seriousness and recidivism factors under 29-29-12. The state actually will first indicate that Ms. Collins argues the wrong standard of review here, not even citing Markham, not citing 29-53-08, not citing clear and convincing standard or contrary to law foundation. Ms. Collins instead cites Kalish. Kalish was overruled in part by Markham, and therefore Ms. Collins has failed to meet her burden. She didn't construct an argument for the proper standard of review. And let's remember, this was not a 26-year sentence. A 26-year sentence is not contemplated by Ohio law. The most, in a definite sentence, the greatest number of years that a defendant can receive is, I believe, 11 years. That's a first-degree felony. You can be sentenced to 11 years. This is an aggregate term of imprisonment. The sentences imposed were 5 years, 6 years, and 3 years 5 times over, for a total term of imprisonment of 26 years. The other thing to remember is that Ms. Collins is not contesting the trial court's imposition of consecutive sentences here either. She doesn't cite 29-29-14 except in the first paragraph of that assignment of error, and then never delves back into it, and the state addresses that in its third footnote, just saying that Ms. Collins says 29-29-14 consecutive sentences, but doesn't contest them. What Ms. Collins is contesting is 29-29-11 and 12, and the court specifically considered them, and that's all that this court needs to look to. This court doesn't then need to go and weigh and balance those factors, because this court really doesn't have any idea what kind of weight the trial court gave to those factors exactly. Under law, the trial court's not required under 29-29-11 to make findings or give the reasons to support its sentence for the purposes and principles. And nor is it required to under 29-29-12 make findings or give reasons for imposing the sentences based on seriousness and recidivism. Ms. Collins does take issue with the trial court considering the string of incidents against this minor victim as a recidivism factor. The state points out that 2912B through E, those factors are non-exhaustive. A says that the trial court can consider factors set forth in B, C, D, E, and F, and, quote, and in addition may consider any other factors that are relevant toward achieving the purposes and principles of sentencing. And 2912D and E allows the sentencing court to consider all of the following that apply, and then later goes on, the statute states, and any other relevant factors. So the court's not constrained by the list that's set forth in those statutes. Ms. Collins beat, hurt, and abused this victim over multiple months, and that's something that could, from the trial court's view, recur with a different victim. And it's important to point out that it's recur, not occur again, but just recur, which makes a big difference. Ms. Collins uses occur in her brief, it's recur. With regard to the second assignment of error, the state will first point out that this should be reviewed under a plain error standard. This was evidence statements made during the sentencing hearing. It doesn't go directly to the sentencing, and therefore needed to be objected to. It was not, and frankly, this was not new material as alleged. The caseworker's statements to the court, it was not new material. It was material that was not surprising or could have blindsided Ms. Collins. These were opinion statements from the caseworker. Again, not material facts under 2914B. These weren't new material facts. These were opinions that the caseworker offered. Frankly, the fact that she contended that this caseworker contended that Ms. Collins tried to murder the minor victim is a legal conclusion too. Again, an opinion, a legal conclusion in that case. It's not a material fact. And to say that she deserved a continuance to try and determine if this caseworker's statement that this was I think it's the worst fact she'd ever seen, or the worst case she'd ever seen in her something like 20 years experience. I mean, that's not something that Ms. Collins could have reasonably overcome. It's not quantifiable and it's not sensible that Ms. Collins could have reviewed this caseworker's life's work. Finally, with the mitigation at sentencing and ineffective assistance of counsel argument, I'm not really sure how much mitigation can be mustered from Ms. Collins from the perspective of an innocent 3-year-old minor victim who's tortured, terrorized, scarred, and traumatized. We have no reason to believe that it was rational or explicable. This little girl's going to cope and deal with the depraved actions for years and years to come. And how much mitigation can really be offered, but the trial counsel did file a sentencing memorandum, did speak somewhat positively, or not somewhat, but in some way positively for Ms. Collins. And also, presumably, the record doesn't reflect it perfectly, but presumably defense counsel provided a packet of additional information the trial court reviewed shortly before the sentencing hearing, which is on transcript 3 of the sentencing hearing. And again, it does require showing of prejudice under the ineffective assistance of counsel argument. None is shown or argued. None is shown in the brief. Frankly, it's hard to believe that any prejudice could be shown given that the trial court's conscience was so shocked that it imposed this 26-year term of imprisonment. Without any questions from the panel, the state asks that the convictions and sentence be affirmed. Thank you.
Ms. Dean, we actually have 4.5 minutes.
Thank you. I will be brief. I just have a few comments regarding some statements made by the state, specifically as it related to the Moore case in the first assignment of error. When we were looking at this case in comparison to the Moore case, which was that case out of the 8th district, the court there, during that colloquy, and I could quote it directly, said, "Do you understand if you plead guilty, you're waiving your trial rights and obviously admitting the truth of the charges with which you are pleading?" That's the question. I think the language there, admitting the truth of the charges which you are pleading, is much different than what we have here. I know there was some comment on violating the law. Which law? You could violate a law by speeding. You could sped to court that day. I mean, there's all sorts of different implications that could be made from that actual phrase, and I think that's why there isn't actual substantial compliance here, and it's a little bit different from the Moore case that's cited out of the 8th district. The only other thing I did want to address, the mitigation aspect by the attorney at the time of sentencing. When we're looking at the appropriate sentence here, arguing seriousness and recidivism factors, I think that was what we're referencing in the mitigation. In this case, there was nothing said at the time of sentencing by the attorney in this case that laid anything out about things that the court had to weigh in making a sentence here, weighing those seriousness and recidivism factors, what the court has to look at when they're looking at the presumption of prison, and I believe that's the argument and what our issue was with counsel at that time. Thank you.
All right, thank you both for your presentations. We will take the matter under advisement, issue our written decision in due course. It will be mailed to both sides as well as posted on the Supreme Court's website and our website.